Good evening. My name is Jerome Deering Bay, Program Director and co-founder of ReformCrimeSentencingNow.org and on Facebook with Rich Moines Productions. And we're here to do episode 5 of the sentencing of the individual that I spoke to in episode 4 regarding the guilty plea in which that individual took, as episode 4 will reveal. We didn't get into names, and I won't get into the names as far as the sentencing aspect, but we want to be able to show you the difference between a guilty plea hearing, a trial, and then the sentencing procedures that occur in federal court as it relates to a conviction or a guilty plea. When I say conviction, I mean a trial by jury or a guilty plea. So this is just relevant to the guilty plea hearing that we presented in episode 4. And I want to get into that. But prior to getting into that, I'd like to give honor to The Spot, a clothing store that's run by Purnell Flag Bay on 2nd and Euclid. And I also like to give honor to Platinum Cuts South, who provides haircuts for individuals that are getting out of prison and the community as a whole. And I would suggest that if you're looking for a recommendable or quality haircut, that you go to Platinum South, and the barbers up there will be more than happy to accommodate you in any manner that you deem fit to meet your style. So, moving forward, tonight we're going to talk about the sentencing procedures that take first and foremost after a person is convicted in federal court or a person pleads guilty in federal court. This doesn't have nothing to do with the state procedures. They're somewhat different than the federal procedures, and will in future episodes describe the difference between state procedures and federal procedures. But be mindful of the fact that just because you go through a state hearing or a federal hearing doesn't mean that the other jurisdiction can't come back and charge you for the same offense in that particular jurisdiction. And we want individuals to be mindful of that, because we understand that a lot of individuals are getting arrested for gun possession, and they're not lawful owners of or licensed to carry a firearm. So if the state arrests you first, you get a state charge, and the feds step in and decide to prosecute you on the federal level, they're doing that because they want you to do more time in prison. So you can do a state sentence, and you can do a federal sentence. So my appeal to the public, especially the public that's out there carrying guns illegally or involved in conduct that's illegal, is to be mindful of the fact that you can find yourself in a precarious situation. And what I mean by that is you can be subjected to a dual sentence, federal and state. And that's something that you don't want to entertain, for the simple reason you think that you finish one sentence and you get ready to get out, go to the halfway house, or get out on parole. No. The other jurisdiction is going to have that particular state or federal jurisdiction hold you until such time that they can reach you, cart you off to county jail, make you sit in that county jail, and be subjected to the sentence that you owe the state or federal government. So, again, due to the rise in gun violence, we want individuals to be conscious of the fact that toting them guns and shooting them guns can lead to consequences that is detrimental to your well-being. And you need to be mindful of that. You know, I understand the conditions out here in so-called free society have risen to the degree that they have risen to, and individuals feel that they need to protect themselves, and I have no problem with that. But you need to be mindful, again, of the consequence that if you're not a licensed gun owner, you're going to be subjected to a term of imprisonment, a term that you may not be able to successfully complete. Now, with that being said, I want to get into the sentencing proceedings from the guilty plea proceedings that I read to you in episode 4, if I'm not mistaken, so that you can see the distinct contradiction of the guilty plea and the sentencing. Now, most individuals that enter into a guilty plea are led there by their attorney. Their attorney suggests to them that it's in their best interest to enter into a guilty plea because they'll get less time. The critical issue that we're speaking on tonight is the distinction between your plea of guilty. This doesn't involve a jury trial because in the prior episode we talked about guilty pleas. So the sentencing proceedings that I'm going to read tonight is incumbent upon that guilty plea. So there's always a contradiction there because most attorneys that pursue their client's plea is telling the client, well, you're looking at 20 years in prison. They'll say 240 months or 360 months, something along that nature. So when an individual hears 240 months, he's not calculating in years what that is. So if an individual is hearing 360 months and hasn't went through these proceedings, he's not really calculating at that time of the amount of time that is. That's why they give it to you in months and not years. 240 months is 20 years in prison. 360 months is 30 years in prison. Life imprisonment on the federal level is life in prison. There's no release of federal parole in federal prison. And individuals need to understand that. Now, I'll say that and get back to that throughout this show. But, as I alluded to during the guilty plea hearing, the individual that I spoke about at that particular hearing out of the Eastern District of Missouri, if I'm not mistaken, or the Western District of Missouri, but he was down in Missouri. And this is the 8th Circuit. Entered into a guilty plea. He entered into a guilty plea because he was told by his attorneys that if you took it to trial, you're going to get a life sentence. The individual ended up pleading guilty with a potential sentence of 262 months. So now he's getting ready to enter into the sentencing phase of that proceeding. And so that's subsequent the guilty plea. And here we go. All right, the court. Thank you. You can be seated. Ready to the defense attorney and ready to the prosecuting attorney, the federal attorney. Both attorneys answer, yes, we're ready. Yes, we're ready. Okay. The court asks, you have had an opportunity to review the pre-sentence investigation report with your client. Is that correct? And so the court is asking the defense attorney this. Now, what is diabolical about that particular statement? The attorney is going to come back and say, yeah, I've went over the pre-sentence investigation report with the defendant. And normally this takes place on one occasion, but the defense attorney is going to say that he talked to the defendant on the phone, he sent him the paperwork, he did this and he did that. So you got to remember, this is a legal document, the pre-sentence investigation report. So most defendants on the federal level don't have an inkling of that language. They don't understand that doctrine. They don't understand that document. But because the defendant has been led to believe that he's going to get the minimum sentence, or she's going to get the minimum sentence, the defendant will always answer, yes, I had an opportunity to go over that. Okay. That just makes it legal for the sentence that you're about ready to receive. Now, the defendant might have his wife in there, his children in there, his mother in there, and his grandparents in there, and people from the community. They're all sitting in the courtroom with him. And this has an impact depending on whether those individuals have an opportunity to stand up and say something to the court in defense of the defendant who's looking at time in prison for selling drugs, toting a pistol, or whatever the crime might be. And that's critical to the proceedings for the simple reason it's always good to have community support if you're out there committing crimes. You need to have people in there supporting you. If you've done things that are worthwhile in the community but went astray, due to economics or whatever the circumstances might be, you need to have people in there supporting you. If you don't have anybody supporting you, you're going to get a raw deal because you're in there by yourself. And I've been in a lot of courtrooms throughout my life where ain't wasn't nobody back there supporting me. And so that gave me an understanding of how important it is. If you look at some of these most profile cases, any individual that's charged with an offense and has been found guilty or entered into a plea, they have character witnesses that come up and testify on their behalf. And this does, in certain instances, a lot for those individuals, depending on who you are and what you have done. Okay, now, moving forward. Yes, Your Honor, that's what the defense attorney responded. And although, this is the court, and although you don't have any objections, the defense attorney didn't have any objection to the pre-sentence report. And this is a critical document because the court relies heavily on what the pre-sentence investigation report recommends. Now, most people that are in federal jurisdiction think that the pre-sentence investigation officer is there to support them in their cause. But unbeknownst to them at that time that they're spilling forth facts about the case, that pre-sentence investigation officer works for the United States government. They don't work for you. So in most circumstances, and I'm gonna go out on a limb, in most circumstances, 90% of the time, that pre-sentence investigative officer, depending on who they are, is going to write a not favorable pre-sentence investigation report on you. And that means that anything that wasn't proven during the course of a trial or a guilty plea, they can add on. It could be facts that's not even related to the crime that you've been charged with, but that's going to be in that report. And the court's going to utilize everything in that document to increase the punishment the court is about to impose upon you. That court is going to use everything that's in that report to demean you in front of your family, your community supporters, and your friends. Because they're going to do everything in their power to support the sentence they're about to impose upon you, unbeknownst to you. This is the game that they play. You out there in the drug game, you're out there in the robbery game, you're out there in the gun-toting game, whatever it may be. This is a whole different ball game here, and they're ruthless. And naturally, they don't want me saying that, but I'm telling you what God loves, and that's the truth. They ruthless when it comes to utilizing facts to increase the amount of time that they impose on certain demographics of our community. And our community needs to be aware of this, because ain't nobody making them aware of this fact. Your attorney ain't going to tell you that. Your state legislator ain't going to tell you that. The church is not going to tell you that. So that's why I'm telling you that. So, again, if you're out there doing this, doing that, you're subjecting yourself to what I consider to be an abuse of the law. Now, and although you don't have any objections that would impact on the guidelines in the report, the most significant of which is that although there were no criminal history points in this particular case for a previous DWI, something minor, driving while intoxicated, conviction, the defendant maintained that he was not the person who received that conviction. Is that correct? Now, this is a minor thing here. The DWI might give him a point or two. So that is an adjustment in the criminal history category. But it's only a point or two. That's irrelevant to the offense in which that defendant pled guilty to. But yet and still, it becomes an argument, because if the government can impose another 1 or 2 points on you for that prior conviction, they want to do that. And the court wants to impose that to increase the guideline range that you're subjected to. Now, is that correct, the court says? The defendant. Yes, Your Honor, and I have no further evidence other than he will tell you the same thing. He has no further evidence, but he wants to argue the issue about the DWI. But there's no evidence that he can put forth to support that he wasn't that person. So It doesn't matter that he wasn't that person. The PSI relied upon it, and the court has the authority to impose that based upon a preponderance of the evidence. He doesn't have the right for a jury determination because he waived that right at the guilty plea hearing to enter into a guilty plea. So once he entered into that guilty plea, he waived all of his constitutional rights to have it presented on a reasonable doubt proceeding. So now it's under the preponderance of the evidence. The preponderance of the evidence. Look up the word in the dictionary and understand what that word means. If you're out there tearing after folly, and what I mean by that is crime. If you're out there doing this and you're out there doing that, you're tearing after folly. And your reward is coming. Yes, Your Honor. And I have no further evidence other than he will tell you the same thing. What does that mean? He will tell you the same thing. The court's looking for evidence to support the fact that he wasn't the person in the DWI. As far as taking his word for it, because he's a defendant in a criminal case in which he pled guilty to, don't mean nothing. It doesn't carry no weight. It's in the record. And the record says you have a DWI. So they can increase your guideline range based upon the record, not what you say. Because you got to have evidence to support everything that it is that you're trying to contradict that will lessen the consequences in this particular case, which is the sentence. But you do acknowledge that doesn't have any impact on the guidelines from the court. Yes, and I explained it to him as well, Your Honor. That's what the defense attorney said. Yeah, I explained that to him. Doesn't matter if you argue that. It doesn't have any impact on the guidelines. Okay, so that's a frivolous argument is the terminology they like to use. It's a frivolous argument. So you arguing about this DWI and you ain't even got no evidence to support it, that you wasn't a person. So it becomes frivolous. Why are you even wasting your time on that argument? Because you ain't got nothing to support that you wasn't that person. What good is it? It doesn't impact the guidelines. Thank you. Those matters have been noted, and since they have no impact on the guidelines, I merely take notice of your position and exception as stated. And as the government attorney, did you have a request for enhanced punishment in this case? The government attorney said, no, Your Honor. The defense wrote a memorandum seeking the minimum. The court. To the defense attorney. I have read your sentencing memorandum. I am a little bit confused, and I should know what the circumstances is in relation to the total offense level, but to the government attorney, could you elaborate on that as to what the circumstances is as reflected in the pre-sentence report in the terms of calculating the defendant's total offensive level? Okay, so what the court is saying is you have a criminal history category and you have a category that deals with your total offensive level. And those two offensive levels jive to create a particular sentencing guidelines that the defendant is subject to. So if you have a criminal history category, let's say it goes from 1 to 6. Anything that's a criminal history category of 6 or better with a base offensive level of 32 or 34, you're subject to 360 months to life imprisonment. If you're over a base offensive level of 37 and you have a criminal history category of 6, you're going to get life in prison. Now, it can be diminished based upon whether or not you go to trial or based upon whether you go and plead guilty. But the fact remains is this here. If in fact you plead guilty and you got a criminal history category of 6 and a base total offensive level of 34 to 37, you're still going to get 360 months in prison. And so what does that equate to? 360 months. That's 30 years in prison. That means you're going to serve 27 years in federal prison. And so instead of espousing the month aspect of the sentence, you need to know that 360 months is 30 years, 240 months is 20 years, and 120 months is 10 years. And so don't look at it in months per se. Because those months equate to years that you're going to do in federal prison. So with that being said, the court went on and asked the defense attorney, I have read your sentencing memorandum and I'm a little bit confused. And I should note that the circumstance in relation to the total offense level, but the government, could you elaborate on that as to what the circumstances is as reflected in the pre-sentence report in terms of calculating the defendant's total offense level? In which way, Your Honor? That's what the government said. The sentencing recommendation does not state a total offensive level. The government. It's a little unusual because in this case, the defendant is a career offender. So what that means, by him citing that you're a career offender, you automatically put in a criminal history category of 6, maybe 5. But most times it's going to be 6. That's the highest criminal history category that you can be in. So your sentence is going to be increased drastically based upon the fact you're a career offender. And you can be a career offender for 2 or 3 minor violations if you're not careful. It depends on how the court views them. And so you need to be conscious of that. That's the reason why you have state authorities pulling you over, arresting you for minor offenses, and building a criminal record. They build that criminal record because somewhere down the line, if you continue on the course that you've been on, you're going to get into federal court. Once you get into federal court, they're going to take that history and make it a part of your criminal history. Those criminal histories invoke points that you're going to get that's going to be subjected to the sentencing range that you're going to get. And if I appear to be passionate or too aggressive in my explanation, it's only because I understand that most individuals that are going into federal court don't understand this. Their attorneys are not talking to them like this. And that's our downfall. So we're subjected to a disparity, not so much on the court imposing the sentence, but because our attorneys don't explain these things to us prior to entering into a guilty plea. So you have no knowledge of this until the subject comes up. And it usually comes up at a sentencing hearing or while you're sitting in jail and somebody with a little knowledge about criminal law explains that to you. But then it's too late because you're already into the guilty plea. And you can't take the guilty plea back. There's only 2 elements, for lack of a better word, that allows you to take a guilty plea back once you entered into that guilty plea. You got to show misconduct or ineffective assistance of counsel or a lack of intelligence, an insufficiency of knowledge to understand the plea that you entered into. But you're caught because you're caught by the mouth. Because during the guilty plea, during the purpose of the plea, the court asks you all the relevant questions that ties you into a knowing and intelligent plea. And you answer in the affirmative because you try to be, appeasing to the court. You don't want to kick up no bull jive. And you want the court to know, yeah, I'm cooperating, I'm entering into this guilty plea, I'm taking my responsibility. And so by you doing that, you lock yourself into the plea. You can't take it back once you enter into it. And it becomes harder post-sentencing to take a plea back. Because remember, once you enter into the guilty plea, you waived all your rights. So once you waive your rights and you enter into that guilty plea, you can't go back and say, oh man, I was tricked. I didn't know this, I didn't know that. Well, if you look into law books, you'll see that ignorance of the law is no excuse. There's no law or constitutional right that allows you to get out of a plea due to ignorance or the insufficiency of knowledge. That's your fault. But you're out here committing crimes now. So you need to be conscious. If you ain't conscious, you shouldn't be out here committing crimes. I'm just telling you what God loves, and that's the truth. Because it's not in your best interest. It's not in your family's best interest. And that's what Reform Crime Sentencing Now.org and Rich Moines Productions is concerned about. How people are out here doing this and they're doing that, and they don't even understand the consequences of their actions. So you may not like the way I'm explaining it to you. You may not like me as a human being. That's on you. But I'm giving it to you in the raw. And I have to give it to you in the raw because I'm concerned about my people. I'm concerned about people in general that are out here committing crimes, doing this and doing that, and they have no inkling of what they're getting into. I was the same way when I was a young man. That's why it cost me 40 years of my life in prison. And so that's why I'm articulating the way I'm articulating at this particular moment in time. Moving on. In which way, Your Honor? The sentencing recommendation does not state a total offense level. It's a little unusual because, in this case, the defendant is a career offender that had a 924 count associated. And what that means is he has a 924C or a 924E. And what those counts are enhancement counts on the federal level. That means you was in possession of a firearm, and you wasn't authorized to be in possession of the firearm. You might have been using that firearm in trafficking, in furtherance the trafficking of a drug crime. So that carries additional time beyond the drug crime. So you might get 360 months for the drug crime, then an additional consecutive 5 years, 7 years, or 10 years for the 924C or E count. So when you get through with the 360 months, they're going to discharge you from it, but you still got an additional 5, 7, or 10 years to do on that firearm count. And individuals out here ain't understanding that, and you need to understand that. So anytime they catch a gun in your house, and you got drugs around, they're going to charge you with a 924C or E. So if you got 2 prior convictions for a felony offense, they can charge you on a 924E. The minimum amount of time you can get for that is 15 years. And they can tie that into the armed career criminal offense under a federal indictment. A 924C is in furtherance of a drug trafficking crime. So if you just carry the firearm, that's only 5 years. If you brandish the firearm, that's 7 years. If you shoot the firearm, that's 10 years. But that's subjected to after you get through doing the drug crime. So you have to do 360 months, let's say, do 27 years on that, then you got 10 years for shooting the firearm. So that's an additional 7 years on the 27 years you've done. That's 34 years you're going to do in prison. There's no parole in federal prison. And so if the law doesn't change in a measurable way, so where you can file a motion under 3582, or if you reserved or preserved your appellate rights, you can't get back. You got an extensive sentence to do, and you got to do the math on that. So you add up the money that you think you're out here making in 34 years, does that add up to the amount of time you're getting ready to do in prison? You can work at McDonald's and get the same amount of money that you're going to be missing out on when you do that 34 years in prison. And you need to think about that. So again, I'm not here to appease you. I'm not here to entertain you. I'm here to give you the facts. And you may not like them the way I'm giving them to you, but that's the truth. And sometimes the truth is stern. But that's how we're going to do it as far as reformcrimesentencing.org and Rich Moynes production is concerned. Moving on. It is a little unusual because in this case, the defendant is a career offender. Criminal history category 6. That had a 924 count associated. When that happens, the rules are a little different, and that the total offense level ends up having no bearing on the sentencing range. The sentencing range is controlled by the career offender table. In some cases, the career table with people having a 924C count, in the defendant's case, the greater of those two would be the original range from the career offender table, which is 262 to 277, and then the 60-month consecutive sentence. The guideline range is determined to be 322 months. So that's less than 30 years in prison right there. But it is unusual that the total offensive level in this case, the way the guidelines are written, doesn't impact his guideline range. The court, thank you. The circumstance that presents itself, given the defendant's criminal history, listen to the words the courts and the attorneys are using, criminal history, category of 6, remember I told you that previously, is that there should be a guideline range of punishment for consideration of from 322 months to 387 months. So they're taking him over the 30-year range with the 387. Is that correct, government? That's correct. I believe you acknowledge that in your sentencing memorandum to the defendant's attorney, But you would like to, well, you request that I consider a sentence of imprisonment less than that, and I have reviewed your memorandum in that regard. Would you like to speak any further to that, sir? The defense attorney, just briefly. I don't have any eloquent speech prepared. But, Judge, this has been a very difficult case for me because basically the evidence was overwhelming. This is what the defense attorney is saying. He's saying that his defendant guilt is based upon overwhelming evidence. But the defense attorney is there to defend you. But he's already admitted to the fact that the evidence is overwhelming. I can't defend against this. Come on, man. The defendant from the beginning has been cooperative. One of the evidentiary problems from the defense point of view upon arrest, he basically admitted everything. Ain't but two things that get caught by the mouth. I said this before. I'm going to say it one more time. A fish and a food. Now, the defense attorney already said his client didn't admit to everything. So what can I do? He admitted to everything. So what can he do? I can't plead his case. For what? He admitted to everything. How can I plead for anything for him? He has to throw himself at the mercy of the court. Now, we're going to see how much mercy the court has as we go on. This is an historical conspiracy. There is actually very little methamphetamine recovered, but the amount is driven largely by what he and other defendants reported. So the government didn't get a lot of controlled substance from the defendant. What the government got is word of mouth. Because when the defendant went in there and agreed to cooperate to get the guilty plea, he told them everything. So they took everything he told him and piled on drug amounts as far as the conspiracy was concerned. So his sentence was increased, not based upon what he was arrested for or what he had in his possession, but what he admitted to. And they didn't even have that in their possession. They didn't have that evidence. They had no physical evidence to support a higher or increased range of punishment. All they had is what he said out of his mouth. And he ain't the only one that did it. You have 97% of the individuals that get incarcerated in federal prison getting hooked by the mouth.
What he said in the plea hearing.
What he said prior to the plea hearing, when they come over and interviewed him. You see what I'm saying? They interview you first. And once they see that you're willing to enter into a guilty plea, then they put that all together in a report and make it a plea agreement and say that you agree to admit to this. Now, what it is, it'll either be 5 grams under statute, federal statute, 50 grams under statute, or more. So the 5 grams and the 50 grams is what establishes the minimum amount of time that you can get. So 5 grams usually means 5 years in prison. 50 grams usually means 10 grams in prison. But because you got prior convictions, that increases the mandatory minimum. So the 5 years go to 10, and the 10 go to 20 or 30. Because then they come back and they hit you with what is called an 851 under Title 21, USC, United States Code. So what that means is you got a prior conviction for dealing in drugs. It might have been marijuana 30 years ago. You see what I'm saying? But they can bring that charge back up and increase your mandatory minimum. This is the mandatory minimum time you're going to get. So you might think that you're looking at under 5 grams, 5 to 40 years. So the minimum is 5 years on that. But if you got a prior conviction for selling drugs or a crime of violence, it increases to 10 years. So that's the minimum amount of time you're going to get in prison is 10 years. You see what I'm saying? If you go to trial, you're going to get that 10 years.
So when dude first got arrested, he came clean on his charges.
Right. Unbeknownst to him, most likely, he didn't know about the enhancements that they were going to impose upon him. And I want to say this here, because I've heard a lot of people talk about this. A lot of people. Well, I can't take the stand because if I take the stand, they're going to use my prior criminal history against me. What did I just describe to you? I described the fact it doesn't matter if you take the stand or not. I would suggest that you take the stand and testify on your behalf for the simple reason they still going to use your prior criminal history against you, whether it be at trial, during the jury, or whatever. or at sentencing. They're still going to use that. You don't get away from that. But your attorneys are always telling you, and Ruth Ann Veal talked about this on the last video that we did, about her attorney not wanting her to take the stand. And she ended up getting a life. And I guess during the sentencing, it was revealed that had the jury had an opportunity to hear her, she would have got second degree. She wouldn't have got a life sentence. But they didn't get an opportunity to hear her side of the story. And your side of the story is important because the law states, I'm not stating this, this is what the law states. The law says, any evidence in the record that is not rebutted, look that word up if you don't understand it. Any evidence that's not in the record, that's not rebutted, is considered as a factual basis. So if you don't, if the evidence that they present is not rebutted, it becomes factual because you never rebutted that. You never diminished or eliminated that particular element of the particular offense. So if they say it was 100 grams, and you don't put on evidence saying, no, it wasn't 100 grams, it was only 5 grams. Then it becomes 100 grams because you never rebut it. It doesn't matter what you say after the fact. If you don't rebut that evidence or that statement, it becomes a factual point that's going to incur you more difficulties than you can even begin to imagine. And again, I learned this through trial and error, man. I mean, I was the same way. That's the only way I'm speaking to it the way I'm speaking to it, with passion and sincerity. Because I learned the hard way. And so by learning that, I'm obligated, based upon my purpose, my aim, to ensure the individuals understand what they're up against when they're out there doing the things that they're doing. And unfortunately, this information isn't available to you in church, in school, or in the community, library. You know, you have to have some type of legal understanding which is incumbent upon your constitutional rights. And your constitutional rights is just a preamble to the law. I mean, the law is vast. And most people don't have time to tarry with getting that education. I had a lot of time to tarry with getting that education, and I got it the hard way. I would just like to reiterate the fact that this individual entered into a plea agreement, and the contradiction to the things that, as far as the sentence is concerned, that he was going to be exposed to was subjected to enhancement provisions that he might have been unaware of. And Rich Moines Productions and Reform Crime Sentencing has an obligation to the community as a whole to make sure that they understand the intricate details of these processes. This guy, as I alluded to in the prior show and again in this show, entered into a plea agreement, admitted to particular facts, and these facts will be brought up subsequent his guilty plea hearing. At the time of his guilty plea hearing, he's thinking that, oh, I'm only going to be subjected to 240 months, something like that. They're 20 years in prison, which is a 17-year sentence that he has to serve on the federal level. Unbeknownst to him, he's unaware of the fact that now, once the pre-sentence investigator gets involved, the pre-sentence investigator is going to be looking at all the things that he admitted to and apply those facts to the recommendation as far as his base offensive level and his criminal history category is concerned. But the individual that entered into the guilty plea is unaware of this at the time. But during the guilty plea hearing, the court makes him aware that it's going to consider all information that's relevant to his criminal history and to his offensive conduct in which he was indicted for. Now, most individuals don't have a clear understanding of that at that particular point in time. It doesn't become clear to them until after the fact. And after the fact is when he gets the draft version of the pre-sentence investigation report, or his attorney tells him or her, well, this is what you're looking at. And the first thing the defendant is going to say, well, man, you told me it was going to only be 120 months. Well, I didn't know you had a prior conviction. That's what the defense attorney's going to say. Because the defense attorney doesn't have the time or the resources to do the necessary work for you to understand all the details that are going to manifest at the subsequent sentencing stage. And again, you can't really fault the defense attorney, because if you're out there doing this and you're doing that, you should be prepared for the consequences of your action. And most people that end up in prison are not prepared for that. They're just out there doing this, slinging out of both drawer legs, toting these pistols, thinking that they this, thinking that they that. And again, like I said, I'm not cracking on you. I'm just giving you some a heads up, man. I'm just giving you some information that you need so that you can make conscious decisions going forward. Because this ain't no game out here. There's nothing fun about committing a crime and going to prison. There's nothing fun about that. Ain't no fun in prison. You might think that there is. You might hear your partners talking about, man, I'm doing this. Man, there ain't no fun in prison. And I'm telling you what God loves. And that's the truth. And with that being said, and for purpose of my memo, Judge, with all due respect, 1 kilogram of methamphetamine is a tremendous amount of methamphetamine, really. 1 kilogram is a tremendous amount of methamphetamine, not really. Man, you got people out here dealing in tons, and they get the same amount of time that this individual got. Tons of methamphetamine, tons of crack cocaine, tons of cocaine. I done rubbed elbows with plenty of them. They got the same amount of time I got, 30 years in prison. I'm looking and saying, damn, you's a kingpin. I ain't nothing. I'm an addict. I get 30 years in prison, you get 30 years in prison. But you bringing in tons, boatloads of this shit. Excuse my language, I didn't mean to go there with that. But truth don't need no support. So this guy got 1 kilogram of methamphetamine, and the first thing they say is it's a lot of methamphetamine. They told me 7.9 grams is a lot of cocaine. 7.9 grams, man. And they gave me 30 years for that. This individual I'm speaking on right now got less time than I did. He got prior criminal history, and he had 1 kilogram of methamphetamine. He gets 262 months. I get 30 years in prison. Come on, man. However, compared to some other defendants that are similarly situated, which I pointed out in the motion, the sentence here to me just seems excessive. And I understand this is a sentence that Congress, in its wisdom, decided was appropriate, but when we talk about guidelines that are reasonable, I think that reasonable doesn't just encompass what Congress determined for a case like this. He needs treatment. So did I. He would not tell you he has been a good person. He has a criminal history as laid out in the PSI, pre-sentence investigation report. I wish I could object to the guideline calculation for my defendant. I think they're right. It's just a question of how much is enough for a drug case. And Judge, I know because I am representing one of the parties in the case that is before you, the case is listed in their United States versus, I can't pronounce the guy's name, Hinestroza and F. Fabio Montano. We are giving almost essentially the same sentence for people who have distributed over 300 pounds of cocaine and executed and hit other people. And I'm not going to belabor that point, Judge, but it just seems like this offense, a sentence that long, is a life sentence. Tell me about it. He's 41 years old, and I think he should be punished, and I think he should be punished. I think 20 years. I can't believe I am asking for that. I think 20 years is a reasonable sentence for 1 kilogram and a prior criminal history. Thank you. The defendant, this is the court. The defendant, is there anything you would like to say this afternoon? Now, here's the defendant now. I would just like to say I am sorry for what I did. If I could turn it around, I would. The court cuts him off at that point and asks the government attorney, Your Honor, I have to disagree with the defense attorney. I believe the guideline sentence in this case for this particular defendant are very appropriate. And I am just going to pick out a couple examples from the pre-sentence report. Remember, I told you how critical that report's going to be, because it's going to paint a picture that allows the government to argue that you should have more time in prison than the minimum sentence. Now, the defense attorney asked for 240 months, which is 20 years in prison. The government attorney come back and said, nah, it should be more than that. But remember, the defense attorney gave an example. He said, man, these guys over here had over 300 pounds of cocaine and was killing people. And they got the same sentence that my defendant's getting. I don't understand that. Make me understand that. How can individuals bringing in tons get the same amount of sentence that got that the defendant has 1 kilogram? What's fair about that? And what's so unique about what I'm saying is this here. In 1978, people in the community and legislators advocated for uniformity within the sentencing process because it dated back to the heroin epidemic back during that particular time. And individuals was getting more time in prison for dealing in heroin based upon the demographics in which they came from. And the demographics is usually tied to nationality or race. But there ain't but one race, and that's the human race. So I use the word nationality. So with that being said, for this particular defendant are very appropriate, and I'm just going to pick out a couple examples for the pre-sentence report. When he was arrested, his first arrest for this case on July 16th, 2005, he told police that he should have shot it out with the police, and he had 2 firearms in which he could have carried that out. He was arrested just a week later, again with cash and methamphetamine a week later, both occurring after he gets revoked. He continues to deal drugs through prison, using his young girlfriend, who you have already seen plead guilty. These priors are violent. His arson was a residential arson occurring after an argument with the owner. And it's fortunate that nobody was injured or killed in that. He, on all 3 of his prior felonies, had extremely poor adjustment to supervision, both probation and parole. Numerous violations, unsuccessful discharge, revocation, and he was clearly not gotten the message that the criminal justice system wants him to obey. Excuse me. The law and follow the rules. I would ask for a sentence within the guideline range of 322 to 387 months. The amount to be left to the court. I would ask that pursuant to 5G 1.3 of the sentencing guidelines, that the sentence run consecutively, not concurrent means together. He's talking about the 924C and the drug charge. So the consecutive charge that the government asked for is whatever time the court gives him for the drug charge, the firearm charge comes along after he's finished with the drug charge. That's a consecutive sentence. To his state parole revocation. Now he's got state parole too. That means he's going to be revocated on a state issue, whichever has first jurisdiction of him. Being that he's in the federal court right now, it appears that the feds have first jurisdiction. So he has to serve all the fed time that he gets with the federal authorities. When he's done, they're going to put him in jail in the local community that he's in, and the state has an opportunity within 30 days to come and get him because he has an outstanding state parole revocation hearing pending. So that means if he has 10 years in the state, once he gets through with that extensive sentence that he has to serve for the feds, he got to go into the state and serve more time. Depending on what state he's in and what type of charge he got on the state level, that could be a very long time in prison, man. It could be upwards to 50 years. And individuals need to be conscious of that. The court. Thank you. Well, defendant, you do have an extensive, this is what the court's saying, you do have an extensive and significant and violent criminal history. I believe that you are a person as exhibited. Now, he might have had all his family in there. That this is the court espousing the factors that are necessary to impose the type of sentence that he's getting ready to impose. So he can't make him look like a good guy. So despite all your family members and community members and stuff like that, the court has to do everything in its power to paint you as the culprit, the violent human being, the drug-dealing, community-destroying individual that you are, in order to impose the sentence it's getting ready to impose upon you, so that the sympathy that may emanate from the people in the audience doesn't take and appear to be relevant to the sentence that the court is getting ready to impose. So he has to make you look like the worst. He got to make you look like John Dillinger, Al Capone, El Chapo, or somebody along that line. He got to make you look bad, man. And that's what they're going to do, especially if you got prior criminal history. Now, if you only got one conviction, then they can't do that because you ain't got no history. That's why they're always bringing up, you see these guys out here shooting. The first thing the media says is, the individual has a prior criminal history. Listen to the media. You ain't got to listen to me. The first thing they say whenever you look at the news, the person that has been involved in the shooting, is they say, this individual has a prior criminal history. A prior criminal history is tied to the conduct that is attributed to you at this point in time. But as young men and young women, we don't understand that. We just out here running haphazardly through life, doing what it is that we do, thinking it is slick. But all that adds up. And in the long run, it's going to have an adverse effect upon your life, man. And you need to understand that. That's why we appeal to you in the manners that we appeal to you. We keep it raw, we keep it real. And you may not like that. I'm not here to put anybody down. I'm not in that position to do that. I'm just giving you the facts and the raw. I know I'm long-winded. Bear with me. Thank you. Society needs to be protected from. And I am going to sentence you on counts 1 to a period of 262 months, count 2 to 120 months, and count 3, 60 months. The sentence under counts 1 and 2 are to run concurrently. That means together. And the sentence under count 3 is to run consecutive. That means after the 262-month sentence, you got to do another 60 months. For a total sentence of 322 months to run consecutive to case number da-da-da-da-da-da. Upon your release from this period of confinement, I'm going to order you be placed on supervised release for a period of 5 years on counts 1 and 3, and 3 years on count 2, with those terms to run concurrently. I find you do not have the ability, listen to this, I find you do not have the ability to pay a fine, and I waive imposition of a fine. So, if you out here selling drugs, or you out here committing a crime, and you ain't even got the ability to pay the fine, why are you out here doing it? You broke. You can't even pay a fine, man. But you out here committing crimes. That's why I said you'd be better off if you worked at McDonald's than out here trying to do this or do that, man. I'm just keeping it real. I told myself that 1,001 times. And when I went into federal prison, I'm sitting up here working in these factories in federal prison for a little bit of nothing. I said, well, man, look at, I ain't making no more than $80 or $100 a month. I got to be a zip damn fool. I'd have been more better off working in a McDonald's or anywhere than out here committing a crime. I got to be a zip damn fool. And that's real talk. I'm in here working for $100 a month, man. I can't pay a fine, I can't hire an attorney, I can't do nothing. But I think I'm out here balling. Really? Come on, man, real talk. I find you do not have the ability to pay a fine, and I waive imposition of a fine. However, you are ordered to pay the United States a special assessment in the amount of $300, which is due immediately, as to count 4 the preliminary forfeiture order finalized and imposed. And defendant, while you are on supervised release, I'm going to order you comply with the standard conditions of supervision that have been adopted by this court, as well as the following special conditions. Okay, that's basically the end of the sentencing transcript. It gets into the supervision aspect of it, and that ain't gonna come about for quite some time. Matter of fact, the individual I'm talking about is still in prison. So he has a very lengthy sentence, and unfortunately for him, things haven't changed to alleviate the sentence that he was subjected to. But individuals that are out here contemplating doing this, contemplating doing that, or currently engaged in this and that, you need to think about what is being said through Rich Moines Productions and ReformCrimeSentencingNow.org. It's not our business to put you down, to belittle you, or anything like that. That's not what we're doing. All we're doing is providing information for you, information that you're not getting out there in them streets. And because of my love for my people and my community, it's incumbent upon me to express it in its most rawest terms, because I've been there and I've done that. I've seen both sides of the fence. I'm not just defending individuals that are in prison. I'm also defending the community as a whole, you know. And what I mean by that is, you know, the things that we do out here in our communities have an adverse effect upon our communities, and we're responsible for that. And the court's going to make us liable for that. The police is going to make you liable for that. That's why they've been getting the things off that they've been getting off historically, because we were unconscious. We didn't know any better. I mean, we followed a particular trend. You might think that's slick, you might think that's cute, but in the long run, when you're sitting in one of them cells that's no bigger than a closet with another individual, you're going to find out that it's not cute at all. There ain't nobody in there to hold your hand. You got to step up and be the person that you are. So if you're out here thinking that you this and you thinking that, when you get in that federal prison or that state prison, you're going to find out that you're not this and you're not that. And with that being said, Rich Moynes Productions with ReformCrimeSentencingNow.org wishes you a very happy and prosperous weekend, and I appreciate you tuning in to our show. Thank you and good night.